Hey folks, Tripp Watson here, the entrepreneur's attorney. Checking in, it is December 22nd, and I am sending y'all some closing thoughts for 2017. A little bit more casual this morning, broadcasting from home. Just trying to get some information out there before the year end. So our office is closed up. I'm sitting here with my morning coffee and just pushing out some thoughts on some legal issues that have popped up in 2017. So we've got the big four that I'm going to be talking about today. The first one is tax reform. So obviously this is a big issue right now. This was passed earlier this week. Biggest tax reform that we've seen really in decades. And the biggest provision that's out there is the decrease in the corporate tax rate from 35% down to 21%. And for those of you that aren't familiar, that's basically the C Corp tax rate. And the problem with that is that the United States was traditionally, in amongst developed countries, one of the higher corporate tax rates. So the C Corp tax strategy was a tax strategy of last resort for most companies. By dropping that rate from 35 to 21, the C Corp tax strategy is now actually a fairly legitimate tax strategy. And so we're going to be looking at that moving forward in potential options for pursuing a C Corp tax strategy outside of your traditional pass-through, such as an LLC or a sole proprietor or an S Corp strategy. We don't know a lot of these provisions yet. It's towards the end of the year. I am slammed right now, and so it's very difficult for me to go through all the provisions, but I will give kind of an update on what some of these provisions are when we start rolling into 2018. Second big change is post-Alice fallout. So for those of you that are not familiar, there's a Supreme Court case called Alice Corp versus CLS Bank. And basically this was a Supreme Court case that involved software patents. And so the Supreme Court basically said that if you have a business method that is either kind of already known, generic, routine, or obvious, you can't protect that business method just by encoding it in software code. And so the ultimate result of that is that basically software patents got gutted. Thousands of software patents overnight lost any type of value that they had. And so now 3 years later, we're still waiting for a lot of the dust to settle. We're still seeing a lot of trial court cases and appeals court cases that are dealing with software patents. This is not an issue that's going to go away. I imagine that we're probably going to have some type of legislative clarification on this type of stuff, because right now software kind of sits in this weird area between copyrights and patents. And there are some situations where you can still get a software patent, but they have to be very, very specific. And while copyright's great, it doesn't necessarily protect if somebody independently develops the exact same thing that you've done. So there's some benefits that are out there to a patent strategy, but because of Alice, it's really kind of gutted that. We're still waiting to see how this gets shaken out. So just be prepared. We're going to see some changes on this front, but we're still relatively recently out from the Supreme Court case, and we really don't know how things are going to shake out. Number three, the big one here in Alabama that's pertinent for a lot of business owners in Alabama is series LLCs. So I talk about LLCs a lot. 2014, Alabama passed an act that allows for series LLCs in the state of Alabama. And what this means is that a series LLC is a segment of an LLC that can be segregated from a liability standpoint from other series within the LLC. So it basically operates as a self-contained holding company. And the benefit of that is that if you have one series that has one product or some type of asset that goes kaplunk, you can jettison that series, you can close that series, and it doesn't affect the other series. This is really popular in real estate investment because you can end up having one holding company and then having a property in a separate series, and each property sits on its own series and segmented from the liability of the other property. So if something happens at one property, the worst case scenario is that you end up getting to recover against that property and not against every property that you own inside the holding company. Now, part of the problem with series LLCs is that we haven't had a whole lot of clarity from the IRS as far as taxation. So The series themselves are each treated as separate tax entities. This is set up based upon a memo that the IRS sent out in 2008. They've been saying that they're going to issue a final ruling on what that's going to look like, but we've been waiting about 9 years now, and we really don't have final rulings on that. But what's interesting is that's not slowing anybody down. I'm seeing a lot of folks set up series LLCs. I'm seeing them become increasingly popular in spite of the IRS not giving final rulings on how the tax treatment is going to be used. I'm not just seeing it necessarily in real estate investment either. I have some serial entrepreneurs that they come up with a new idea. They want to put it in a series. They don't want to set up a new LLC and go through all that process, but they can set up a series, test it out, and if the thing doesn't work 3 months later, they can close it down. It's really simple as far as the mechanics of it. I'm also seeing it for investors. Investors are doing this, and so you might have an investment pool, and then whoever's a member of that investment pool, maybe they want to get involved in this one investment and maybe not another investment, so they can set up a series within that LLC for investment purposes. So I'm seeing angels and venture capitalists that are using series in order to invest and to facilitate that. I'm also seeing it in a little bit of a estate planning context. So there are some benefits to an LLC. For instance, since it's treated under partnership law, you can automatically revert your interest in an LLC to somebody else. So I am seeing LLCs being used as an estate planning strategy, especially with some of the changes that are going in with the estate tax changes. A lot of the pressures that used to be there as far as to avoid an LLC are no longer there, or they're decreasing. So a lot of folks are using LLCs because they offer a lot more flexibility than a trust, for instance. There aren't as many tax benefits as you might have in a trust, but as far as passing it outside of probate, there's definitely a lot of benefits. Now, number 4, the other big issue that we have specifically in the state of Alabama is non-competes. And specifically, the issue that we have is nobody knows what's going on. So non-competes have become increasingly popular in the last 10 years or so, probably across the country. And basically what a non-compete is that either through the contracts that I have with my employer, that I'm not allowed to call or solicit not only a customer, but I might not even be able to work in a competing company. So if I work at AT&T, I may not be able to go work at Verizon, for instance. These are really common when you see them applied to salespeople. The main idea is that if you have customer relationships, we don't want you to be taking those customer relationships to another company. Now, that creates a problem, though, because a lot of these companies are starting to apply these to non-salespeople, people that are internal, people that might have knowledge about how the company works, but maybe not an external relationship. And in Alabama, we actually have a code provision that bans these. So it's 8-1-1 used to be the old code provision. But people started to enforce these non-competes, and the courts in Alabama really were just all over the place with how they enforced them. And so they changed the law back in 2016 to clarify what you needed to have, what you needed to be able to show, and then potential exemptions under the non-competes. And so if you wanted to have a non-compete, it gave you a step-by-step. You have to do A, B, and C. And if you are deficient in either A, B, or C, if any of those is deficient, you do not have an enforceable non-compete. So since 2016, we have had no appellate cases in the state of Alabama addressing the new Restrictive Covenants Act. So the reason that that's interesting is that you could almost guarantee that there was going to be a fairly routine case that came out that at least gave you an idea of what we were looking at on an annual basis. And we haven't had that. So I don't know whether it's because companies have put in language to comply with the act and we're waiting for those cases to trickle through the system, or whether people are just afraid to enforce under the new provisions. Either maybe they are in compliance with the act and it's pretty clear that they are in compliance, or a company's non-compete is clearly deficient according to the act. So it might offer some pre-dispute clarity on whether or not a lot of these contracts are enforceable or not. The bottom line is that we don't really know what's going to end up happening here. So we think that there's some good case law that's out there under the prior act, but with the new act, we don't have a whole lot of clarity. The statute's pretty clear, but we don't really know from an appeal standpoint how the courts are going to enforce these. So that's a little bit of a wild card that we have that's still going to be shaking out over the next 5 to 10 years, as a lot of these cases end up getting filed and trickling through the appeals process. So those are the big four changes that I see that are affecting Alabama business owners. Specifically, like I said, the big 950-pound gorilla in the room is going to be the tax reform. Number two, the increasing skepticism towards software patents, the prevalence of series LLCs and their increasing popularity, and the questionable treatment towards non-competes. If there's anything that I missed, if there's a legal concept or a legal update that I've dropped out of here, be sure to let me know in the comments because I'd like to hear what you have to think. So this is Tripp Watson, the entrepreneur's attorney at the Watson firm here in Birmingham, Alabama, and wishing you all a Merry Christmas and a Happy New Year. I will see y'all again in 2018.